Stop everything. The tension in this courtroom is insane. Defendants are pleading guilty, probation is on the line, and one wrong move could change their lives forever. Can you imagine being in their shoes? Let's break down every shocking moment.
And good morning, Ms. Holmes. Good morning. Will your client waive the formal reading of the indictment? Yes. Mr. Harmon, in cause number 24, DCCR 1612, you are charged with a second-degree felony offense of assault of a peace officer from July 9th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Good morning, everyone. Right off the bat, the tension is palpable as Miss Holmes and Mr. Harmon face the court. Notice how formal the proceedings are. Every word counts here. Harmon is waiving the formal reading, which is a big move. It means he's fully aware of the consequences. This is the start of a legal dance that could determine his freedom for the next several years. Can you feel the weight of the courtroom already?
Speak up, please. And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? We got state tenders number 1. Objection. It's admitted. Is there any evidence that Mr. Harmon is not competent? Yeah. All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. Then it'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond?
I have 1%, Your Honor, but all that happened was doing bond, so it can't be balance. But so, okay, because you want to proceed on finance, if he gets released, that's something taken.
They didn't file the cases, and then I have a...
Here's where it gets intense. The judge is laying out probation terms, fines, and living arrangements. $1,000 bond, mandatory pre-sentence interviews, and strict living conditions. It's all very structured. The stakes are high. Follow the rules or risk everything. And the judge doesn't sugarcoat it. Any new offense could void the plea agreement. You can see the worry in Harmon's face. This is why courtroom strategy and attention to detail are everything in these cases.
I don't know that I can. Where are you going to live when you get out, Mr. Harmon? I cannot understand you. Right. But that's where all this happens? No, this is a different place. Okay. So if I let you out today, I want to... What's the name of the friends that you're saying that you're going to live with? Say it again. Arlie? Iron? How you spell it? Gotcha. Last name Woods? Okay. So at least while this is pending, if I let you out today, I'm ordering that you live with them and not at the other place where all of this happened. Okay? Maybe later, if everything's going well and you want to have some relationship with whoever this was, I'll get more information about that in the pre-sentence report, and we can talk about it at sentencing. But what I'm going to do today, because of your plea for probation, is I'm going to reduce your bond in your case to $1,000. So if you're able to make that bond, there's a couple of things that are very important. First thing is that if you make the bond, you go directly to the probation department so they can start that interview process for your pre-sentence report. If you don't go there and do that, then you run the risk of me not accepting this plea agreement. Things could be much worse. You understand? Also, a condition of that bond is that you are going to live with Aaron Woods. No one else until either I give you permission or we discuss it again. You understand? Also, if you are arrested for anything, if you make that bond and you're arrested for anything before you come back for sentencing, obviously sentencing goes. I don't have to sentence you. Okay? All right. See you at sentencing. Thank you, Mr. Nichols. Okay. Good morning. Are you Caprina Swan? And Miss Swan, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion? Ms. Swan, in cause number 24, DCCR 1362, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 29th, 2024, and that was for the offense of aggravated robbery, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed for the months of January, February, and March of 2025. And is that true or not true? True or not? Listen to the question. True. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you admitted to using cocaine and alcohol on January 7th, 2025. And is that true or not true? Count 3 alleges that you failed to participate in the mental health services and follow all recommendations of that. Is that true or not true? Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count
Now
6
pay
alleges...
attention. This is a serious moment. Caprina Swan's probation violations are being addressed, and the judge explains in no uncertain terms. One more mistake, and prison time could be life-altering. From failing mental health programs to substance use, the court is giving her a clear second chance. It's rare to see such a mix of compassion and strict authority, but that's how probation works. It's your life on the line. Could you handle that pressure?
Count 6 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy program. Is that true or not true?
True.
And then count 7 alleges that you're behind in your court assessed fees. And is that true or not true? All right, did you enter your pleas of true to counts 1 through 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation. But it's my understanding that the probation department and the state are willing to give you a chance today to go to the special needs safety program, which will help you hopefully get all of these issues behind you, learn how to make better decisions, stop using drugs, get the mental health treatment you need so that you can be successful on probation. I want to make sure you understand that this is your second chance now, and you will not get a third. You are on probation for a first-degree felony. Today, right now, I could send you to prison for the rest of your life. The rest of your life, from 5 years up to 50, 60, 70, the rest of your life for violating probation on this type of offense. So you need to take advantage of everything that they teach you, because when you get out of safety, you'll have aftercare, you'll have people to help you, find places to live, and all of that. But it's going to be up to you to take advantage of those things. Do you understand? All right. I'm also going to, because you didn't report and because this is going to take some time, I'm also going to extend your probation for a period of 2 years. So you're now on a 7-year probation instead of a 5-year probation. Now, every single person who's on probation in my court and any court can get off their probations early if they do everything they're supposed to. So it doesn't have to be 7 years, but it would take you getting everything in line real quick and doing everything right. You understand?
Yes.
All right. Good luck to you, ma'am. You go back with the bailiff. They're going to get some paperwork for you to sign about safety. You need to sign that when they get it to you.
Thank you.
Thank you. Good morning, sir. Are you Rontez Williams? And Ms. Holmes, will your client waive formal reading of the indictment? Mr. Williams, in cause number 22-40090, you're charged with a third-degree felony offense of fraudulent use of identifying information from January 20th of 2022. How do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? Yep. She has to hear you too over here. All right, they're taking everything down. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of fraudulent use of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts.
Next, we see multiple defendants entering guilty pleas, from fraudulent use of identifying info to resisting arrest. The judge reads each plea slowly, ensuring competence and understanding. Credit for time served, written admonishments about firearms, and careful sentence explanations. It's all part protecting both the law and the defendant's rights. Notice how precise and procedural every step is. One slip could be fatal in court.
You can talk. All right. Good luck to you, sir. You can go back with the bailiff. See, Mr. Parker on Laddie Johnson. All right, are you Laddie Johnson? And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Johnson, in cause number 24, DCCR 2388, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor resisting arrest, and that's from October 24th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And are you a U.S. citizen, sir? State tenders number 1. It's admitted. Is there any evidence that Mr. Johnson's not competent? All right, Mr. Johnson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of resisting arrest. Sentence you in accordance with that agreement to a term of 200 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Y'all have already got the 200 days. Y'all confirmed that. So it looks like you have 200 days credit, and so you should be. So you're getting 200 days, and you have 200 days even. Okay. Okay. All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Good luck to you, sir. You can go back with the bailiff. Good. Good morning. Are you McKaylin Jones? And Mr. Rojas, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your...
Sorry, just
Oh, that's okay.
one count 2, 3, and 4.
Thank you. I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct?
Yes.
And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point Coupe in Louisiana. And is that true or not true? True or not true? Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true? And then count 4 alleges that you committed the offense possession of a Schedule I drug on May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true? Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily? Did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Jones is not competent?
Oh, yeah.
Well, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison.
Finally, the probation revocation and bond discussions show just how complex court proceedings are. From DWI with a child passenger theft and controlled substance cases, every detail is dissected. The judge balances legal fairness, public safety, and rehabilitation efforts. And the probation system? It's designed to give second chances, but only if the defendant fully complies. Courtroom drama isn't just about verdicts. It's about real people, high stakes, and life-changing consequences. What would you do in their shoes?